novelist, war crimes investigator Lawrence Douglas. So thank you all for coming. I'll say also thank you for the Center for Jewish History. So the American Jewish Historical Society is just one of 5 partners in this building in the Center for Jewish History. So thank you for hosting us here. Now I'm gonna present our speaker. And I'll just say the talk is gonna run about 45 minutes, then we'll go into Q&A. And then after the program, we have books to sell. So The Right Wrong Man, the book we're gonna celebrate today and talk about, is gonna be on sale. And of course, the author is here for signing, so please stay for that. So again, very honored to have Lawrence Douglas here. He teaches at Amherst College, where he is the James J. Grossfeld Professor of Law, Jurisprudence, and Social Thought. He earned his JD at Yale Law School, his MA from Columbia University, his BA from Brown University, and an honorary MA from Amherst College. Professor Douglas is the author of 6 books, both fiction and nonfiction. His scholarly books include The Memory of Judgment, Making Law and History in the Trials of the Holocaust, and The Right Wrong Man, John Demjanjuk and the Last Great Nazi War Crimes Trial, both published by Princeton University Press, January 16th. His novels include The Vices, a finalist for the National Jewish Book Award in 2011, and The Catastrophist, right? His articles and essays have appeared in numerous publications, such as the New York Times, the Washington Post, the LA Times, Frankfurter Allgemeine Zeitung, the Guardian, the Irish Times, the New Yorker, the Times Literary Supplement, and Harper's. He also received many fellowships and from the National Endowment of the Humanities, the American Council of Learned Societies, the United States Holocaust Memorial Museum, and the Institute for International Education. And of course, lectured, and is going to lecture widely, served as a visiting professor at the University of London as well, and at Humboldt University in Berlin. So with no further ado, join me in welcoming Lawrence Douglas.
Thanks so much for the very generous introduction. I now see that my brother is here, so I actually can begin with the talk. I want to actually start this talk tonight with a story about memory. And this goes back to the mid-1970s in Hamburg, where German prosecutors, they tried a number of SS officials who had run a camp called Czerniki. The Czerniki camp was an SS facility that had been located near Lublin in Poland. During the Holocaust, the SS had recruited about 5,000 Eastern Europeans, mostly Ukrainians, who had been taken as prisoners of war by the Germans. And they had basically trained these former POWs to then serve as death camp guards. And Jews were even kept on hand at this Czerniki facility so that guards could practice their guarding techniques. And one famous alumnus of this Czerniki camp was John Demjanjuk, about whom we'll hear more tonight. And during this trial in 1975, German prosecutors brought a case against a handful of SS men who had overseen this Czerniki training camp. And during the trial in Hamburg, a Jewish survivor of the camp identified one of the SS men as Obersturmbannführer Klink. Now, no other survivors could identify the SS lieutenant colonel by name. So the witness's identification was absolutely crucial. The only problem was prosecutors had never encountered the record of an SS Colonel Klink at Trinity. And they were actually perplexed by the odd name, which is not a typical German name. And it came out ultimately that the survivor had apparently confused her Trinity tormentor with another man. And of course, those of a certain age will recognize this man as the bungling, monocled colonel who presided over the fictitious Stalag 13 in the American sitcom Hogan's Heroes. And in the survivor's mind, the Colonel Klink of the TV show had become confused with the colonel at Trinity. And she then later insisted that the two had looked quite similar to one another. Now, I begin with this story because far from just idiosyncratic and odd, I actually believe that it represents a crucial problem that trials of the Holocaust have faced, and as we'll see, it represented a very specific problem in the case against John Demjanjuk. Now, to appreciate the more general point, I think we just kind of need to step back for a moment and to consider how the atrocities of the Holocaust, how they fundamentally challenged and unsettled conventional understandings of criminality. So I think conventionally, and this might be familiar to those of you in the audience who studied law, but I think it's fair to say that conventionally, the law construes crimes as deviant acts. That is, acts of deviance that are typically committed by one individual against another individual, and that these acts are understood to harm community order. Now, different legal systems might reach different conclusions about which specific acts constitute such a threat, but all legal codes condemn certain foundational wrongs. I mean, these foundational wrongs, most typically and most emphatically, of course, the crime of murder. And when it comes to such wrongs, such a wrong as murder, the modern nation state, of course, responds very aggressively. It mobilizes and deploys an investigatory and judicial resources to the end of apprehending, prosecuting, and ultimately punishing perpetrators. And in the classics of Western political theory that some of you might have studied years ago, the state is really understood as the bulwark of order. It's the force that protects us from the act of violence from other people within our civil society. That's what the police do. They protect us from menace on the streets. I think it's fair to say that Nazi crimes, they kind of exploded this classic model of criminality. And they exploded the assumption that it's the private violence of other persons that represents the most basic threat to the fabric of social life. Because Nazism, of course, revealed the terrible capacity of the state itself to break bad, a phenomenon that the German philosopher Karl Jaspers designated with the term Verbrecherstaat, which just means criminal state. And Jaspers' term, I think Jaspers' term, was attempting to illuminate how Nazism turned the state itself into the principal perpetrator of crimes, the very agent of criminality. If we look, for example, at the opening address of Robert Jackson, former Supreme Court Justice who then led the American prosecution at Nuremberg, Jackson was keenly aware of the legal challenge that was posed by the Verbrecherstaat, the criminal state. And he put it this way. He said, this is a quotation from Justice Jackson when he was the lead prosecutor. He said, civilization asks whether law is so laggard as to be utterly helpless to deal with crimes of this magnitude by criminals of this order of importance. The Nuremberg trial, and here we see just an image taken from the Nuremberg trial. This is, again, the major trial that was run as an international tribunal, first international criminal tribunal in human history. But the Nuremberg trial and its progeny, the trials that followed afterwards, I think they offered a distinctive answer to the question that Jackson raised. Nuremberg insisted that the law was adequate. It was adequate to deal with the crimes of the criminal state, but the effort would nonetheless require an extraordinary legal innovations. And mastering the crimes of the criminal state, it would require, on the one hand, novel jurisdictional principles. It would require rather unorthodox evidentiary conventions. But most of all, it would require new categories of wrongdoing. And these new categories of wrongdoing, it was understood, they would have to be kind of sufficiently flexible on the one hand, and also sufficiently capacious to handle crimes that had spanned a continent, that had enlisted the participation of tens of thousands of perpetrators, and that had been supported with a complex organizational and logistical apparatus. And of these new novel incriminations, two of course stand out, and one of them is crimes against humanity, and the other is the concept of genocide. Nuremberg, some of you might have read about the Nuremberg trial. Nuremberg was not, in the first instance, a trial about the crimes of the Holocaust. The main charge that was brought against the 21 defendants who were in the dock at Nuremberg was that they had committed so-called crimes against the peace. That is, that they had launched an aggressive war in violation of international law. But nonetheless, Nuremberg did confer judicial recognition on what was then called crimes against humanity. The first time that term was actually used as a legal term. And that was the term that the Nuremberg prosecutors used in order to describe state-sponsored atrocities. The prosecution then used that novel concept of crimes against humanity basically as the principal challenge by which most of the evidence of the Holocaust entered into the court at Nuremberg. Genocide, of course, is this is the term that was coined by Raphael Lemkin. Lemkin was a Polish Jewish advisor to the U.S. War Department. And in 1944, he kind of reached the conclusion that we needed a new word, a new term to describe the Nazi treatment of Jews in occupied countries. And what he did is he wedded a ancient Greek term for group, genus, with the Latin term for killing, side. And he came up, of course, with his new term, the term genocide. And this idea of genocide was meant to denote something distinct from mass murder, and indeed something more grave than just mass murder. According to Lemkin, this is a quotation from Lemkin, it was meant to describe a, quote, a coordinated destruction of the essential foundations of the life of groups with the aim of annihilating the groups themselves. The effort to punish Nazi crimes also gave rise to the creation of, in addition to these novel incriminations, it gave rise to special courts, some of them international, such as the Nuremberg Court, and some of them domestic. And these courts have been especially tasked with trying crimes of genocidal sweep. And I think, in fact, it would be no exaggeration to say that the area that we now describe as international criminal law, that international criminal law, in large measure, owes its existence to the law's attempt to grapple with the legacy of Nazi mass atrocity. And these important legal innovations, they ultimately authorized the prosecution of a great many perpetrators of the Holocaust. Again, all the way from principal architects to zealous bureaucrats and even to hands-on exterminators. But at the same time that these innovations did make possible a lot of prosecutions, and a lot of very important prosecutions, I think it would be wrong to think that the innovations made the act of conducting these trials a simple matter. To the contrary, I think it's fair to say that these trials invariably posed very complex issues which return us to our point of departure, this story about memory. At Nuremberg, prosecutors structured their case around captured documentary evidence, rather than, say, on eyewitnesses to Nazi atrocities. That is, prosecutors, they actually worried that Nazi crimes, they were of such a kind of extreme nature that prosecutors worried that survivor testimony would be dismissed as exaggerated or perhaps even fabricated. So they relied very heavily on documents. And this is just tries to give you a sense of the fantastic inundation of documents in the prosecutorial office at Nuremberg. The decision to privilege the document over the voice of the eyewitness or the survivor, I think we can also say that politics played a role as well. The British clearly worried that highlighting the suffering of Jews would complicate efforts to restrict Jewish immigration to Palestine. And so Jewish survivors, they were largely excluded from the witness stand. So again, the bulk of the evidence that was submitted was captured Nazi communiques or documents. And again, this material was understood to be harder, more reliable than the material from eyewitness testimony. And so, as I said, Nuremberg was largely a trial by document, absent the voice of witnesses. Now, whatever else we might say about this approach, and it had a certain logic to it, but it had one very clear consequence. And the consequence was well formulated by Rebecca West. Some of you might be familiar with Rebecca West, the British writer who actually was covering the Nuremberg trial for the Daily Telegraph. And she memorably described the Nuremberg trial, as a citadel of boredom. It was exceptionally dull trial. This spectacular first international criminal court in human history was spectacularly dull, because what happened in court for hours upon hours and hours is prosecutors would get up and they would read documents into the record. And it really kind of drained the trial of a very critical human dimension. And in fact, some of the critics of the trial went so far as to say that by excluding the voice of survivors, that Nuremberg was actually, in a kind of perverse way, completing the work of the perpetrators, in as much as the victims were again left at this trial. They were left absent, they were left voiceless, they were basically left erased from memory. If we move forward to the trial of Adolf Eichmann in 1961, Eichmann, of course, the person who was responsible for deportations of Jews to death camps. The Jerusalem trial of Eichmann very consciously tried to correct Nuremberg's misstep. The Eichmann trial was very consciously structured around the testimony of eyewitness and eyewitness survivors, or just to say survivors, Holocaust survivors. Israeli Chief Prosecutor Gideon Hausner, he openly acknowledged, he wrote a memoir in which he openly acknowledged that for him, winning a conviction and securing the death penalty against Eichmann were not the exclusive ends of the trial. He very specifically wanted to create a trial that would, in his words, would create a living memory of a living record of the gigantic human and national disaster. And he thought they could create such a record by telling Holocaust history through the lived memory of survivor witnesses. And this is just one of the famous survivor witnesses who testified, Abba Kovner, who was a very important figure in the resistance in Europe, but also became, in the years afterwards, he was one of Israel's leading poets. So he was one of many people who testified at the Eichmann trial. And this approach of trying to tell Holocaust history through the lived memory of survivors, it ended up being wildly successful. Far more successful than the chief prosecutor anticipated, or even Ben-Gurion anticipated. And I think it's fair to say that the Eichmann trial really became the exemplary Holocaust trial, the most important and successful Holocaust trial. That is, the trial that most successfully placed memory in the service of justice, and also vice versa. Nonetheless, I think it's fair to say that the strategy was not uncontroversial. It raised all sorts of difficult questions, such as, Is it proper to push a trial in the direction of becoming what almost looks like an oral history project? Is a criminal trial the right venue for honoring the memories of those who have endured unspeakable atrocities? The Eichmann trial, at the very least, it showcased the power of using trials to serve the interests of memory. But the dangers of that approach, were dramatically exposed in the other great trial, the other great Holocaust trial that was staged in Israel. And this was the trial of John Demjanjuk that began in Jerusalem in 1987, about a quarter of a century after Eichmann's execution. And let me just tell you something a little about the, give you a little kind of a thumbnail sketch of the exceptionally bizarre history of the Demyanjuk case. So Demjanjuk was born, Ivan Demjanjuk, in the Ukraine in 1920. He was drafted into the Soviet Red Army after the invasion, 1941. He was taken as a prisoner of war by the Wehrmacht, by the German army, in the spring of 1942. One thing that's important to bear in mind is that after he was taken prisoner of war, throughout the rest of his life, Demjanjuk basically insisted that after he was taken prisoner of war by the Wehrmacht, that's where he remained. He remained a prisoner of war throughout the rest of the war. After the war ends, Demjanjuk bounces around some displaced persons camps for several years. He ends up immigrating to the United States in 1952. In 1958, he becomes a naturalized citizen of the United States. On the same day that he becomes a citizen, he officially changes his name from Ivan Demjanjuk to John Demjanjuk. And he basically then goes about assembling a rather successful blue-collar, middle-class suburban life in outside of Cleveland, Ohio. He works as a machinist at Ford at a time when well-paid union jobs permitted blue-collar workers to live really quite comfortably in a nice suburban house in Seven Hills, a suburb of Cleveland. And there he lived, raising a family, until his legal trouble started in 1975. And in 1975, American prosecutors got word, or they received evidence, indicating that Demjanjuk had actually, after being taken as a prisoner of war by the Germans, that he had then basically collaborated with the SS and had served as a death camp guard. Now, the American testimony, the American evidence was not being prepared by American prosecutors with an eye towards bringing criminal charges against Demjanjuk. As a technical matter, American courts do not have jurisdiction over the crimes that took place in Europe against other Europeans. So the idea in launching this investigation of Demjanjuk was never to bring criminal charges domestically. The idea instead was to bring civil charges against Demjanjuk, because one thing that Americans could do is they could charge him with having falsified information on his immigration forms, and as a result of that, they could denaturalize him and ultimately deport him to a country that perhaps could bring criminal charges against him. And so that was the goal of the American prosecutors, and ultimately, Demjanjuk was denaturalized, and he was extradited to Israel to stand trial as a death camp guard. Only he wasn't any old death camp guard. This was a death camp guard who was allegedly, he was allegedly known as Ivan Grozny, Ivan the Terrible. And this was a death camp guard from the Treblinka camp, whose legendary sadism, legendary brutality, had made him a pretty well-known figure, even going all the way back to the Eichmann trial. That is, if you read through the transcript of the Eichmann trial, you'll see that survivors at that time who testified at Eichmann, survivors from Treblinka, while they were just offering testimony about their experience during the Holocaust, they all highlighted this particularly brutal guard at Treblinka, this Ivan the Terrible. And Demjanjuk stood trial as Ivan the Terrible of Treblinka. And since this is a book talk, I thought I would maybe very, very briefly just read a little passage from the book that describes Demjanjuk's time on the stand during this trial. Recall, Demjanjuk's first line of defense was always, I never served as a camp guard anywhere. I was a POW throughout the war. So let me just, if it's okay, I'm just going to read this little passage that describes his testimony, because he did testify on his own behalf in Israel. Demjanjuk began his testimony 5 months into the trial, and his 7 days facing his judges doomed him as much as any evidence submitted by the prosecution. A boisterous courtroom audience repeatedly greeted his testimony with jeers of derision. When a Hebrew interpreter misreported Demjanjuk's utterance that in 1941 he had been 82 yards tall, spectators assumed the defendant was mocking the court and exploded in shouts of outrage. More generally, Demjanjuk's testimony offers a textbook illustration of a simple but elusive truth. If you intend to lie about your past, it's important to get the story straight from the outset. By the time that he took the stand in Jerusalem, Demjanjuk had made numerous statements to American officials over the years, creating a paper trail so rich in contradiction that Israeli prosecutors must have drooled in anticipation. Read in chronological order, his statements suggest that the speaker suffered from a disease new to the annals of neurology, reverse dementia. Facts, items, whole events left maddeningly vague in earlier statements or omitted altogether gradually take form over time, grow sharp, and crystallize in later testimony. For instance, in his first deposition with lawyers from the Justice Department in 1978, Demjanjuk reported that after his capture by the Wehrmacht, the German army, he was taken to a POW camp in Rovno, Poland, where he slept in a railroad car and was put to work altering the gauge of rail tracks. He also spoke of a second camp, but we could not recall its whereabouts. I forget now. 3 years later, testifying at his denaturalization trial in 1981, he recalled the site of the second POW camp as Chelm, Poland. His task in this camp, he said, was to build barracks. Now in Israel, he recalled that while it was true that he had built a few barracks in Chelm, he had mainly dug peat, and did so with a group of 60 or other POWs, whom he could, quote, see before my eyes. Yet he could not recall a single surname of his fellow prisoners, and he could not recall how long he had stayed there. Some changes, expansions, and emendations in Demjanjuk's testimony could perhaps be overlooked, but not Chelm. Chelm was his alibi. By his own admission, Demjanjuk had spent only a few weeks at Rovno, probably no more than 3. By contrast, he claimed to have been in Chelm for at the very least 18 months. That is, during the entire period of his alleged service as a death camp guard. Struggling to account for this disturbing bout of forgetfulness, Demjanjuk first blamed the very trauma of the POW experience, asserting, quote, I would like to forget all that I had been through, end quote. Yet when it came to describing other traumatic episodes in his life, of which admittedly there were many, Demjanjuk demonstrated a precise, indeed an excellent memory. He was able, for example, to recall the names and whereabouts of all 4 Army hospitals where he was treated for a shrapnel wound, suffered early in his wartime service with the Red Army. When pressed by Israeli prosecutors to account for having forgotten Chelm, his alibi, at his first deposition, Demjanjuk could provide no answer. Mr. Prosecutor, what do you want from a person who only had 4 years of schooling? I forgot. I can't say why I forgot, I forgot. So, largely as a result of this very poor performance on the stand, this is an image of Demjanjuk in the Israeli trial, in part because of his poor performance on the stand, but much more because of identifications of survivor witnesses. Demjanjuk was convicted, and he was convicted as this Ivan the Terrible of Treblinka. Now, the accusations against Demjanjuk at the Israeli trial, they were certainly gruesome, but they actually fit quite easily into what I described at the outset as this kind of standard model of criminality. That is, Ivan the Terrible was kind of a monster. He was kind of an evil character. He was a bad, bad person. And after 18 months of trial in Israel, Demjanjuk was convicted, and he was sentenced to death. Again, based on his performance on the stand, but more emphatically and specifically based on the eyewitness testimony of a number of Treblinka survivors who all swore with complete certainty that Demjanjuk had been their former tormentor. And they were all wrong. All wrong. Evidence that emerged during the appellate phase indicated that Ivan the Terrible had been a completely different Ukrainian named Ivan Marchenko. It just so happened it was actually quite fortuitous for Demjanjuk, but the appellate phase of his trial coincided with the unraveling of the Soviet Union. And what this meant is that there were files and files and files of the KGB that had not been accessible to either defense lawyers or prosecutors that suddenly became available. And this material showed very clearly that Ivan the Terrible was this other guy named Marchenko and not Demjanjuk. And so the Israelis were forced to ultimately overturn the conviction. However, and this makes everything that much more bizarre, and I think it goes to one of the reasons why this case continues to fascinate the collective imagination is the material, the evidence that came out wasn't entirely exculpatory. That is, even though it became clear that Israel was about to execute the wrong guy as Ivan the Terrible, it also was very clear that Demjanjuk was kind of Ivan the not-so-hot. That is, it became really quite clear that he had been, in fact, a death camp guard, only not at Treblinka, but at Sobibor. Nonetheless, the Israelis were kind of caught somewhat in a pickle, and they ultimately said, look, we didn't try him on the Sobibor charges, we tried him on the Treblinka charges, we're going to acquit him and release him. He returns to the United States. And the Americans are now, they now feel, what are we doing with this guy back in our country? This is a guy who, if he wasn't Ivan the Terrible of Treblinka, he still is a terrible Ivan from Sobibor. And so what the Americans do is they basically refile denaturalization charges against him, deportation charges, and this ultimately exhausts a lot of time, it exhausts a lot of money, and exhausts, of course, a lot of judicial resources. And it results in Demjanjuk's deportation to Germany in the spring of 2009. He's tried, the trial begins in November of 2009. He's tried as an accessory to the murder of 28,000 Jews during his time at Sobibor. He's convicted in 2011, and he dies in 2012 while his case was being appealed. In contrast though, to the Eichmann trial and Demjanjuk's first Israeli trial, that is, Demjanjuk's first trial in Israel, his Munich trial was almost entirely absent the lived memory of survivors. Actually, by 2009, there were no more than 8 Sobibor survivors on planet Earth. And actually, before the trial began, 2 of them came forward. 2 of these 8 actually came forward, claiming now to be able to positively identify Demjanjuk. They suddenly said, oh yes, yes, he does look familiar. We can come to Munich and testify. And perhaps predictably, the German prosecutors said, "Nein, danke." And of course they did so because they were not about to repeat the disaster that had taken place in Jerusalem. So this ultimately became a trial that was absent the lived memory of survivors. So what kind of trial then was it? It really became a trial by history. And by that, it was not entirely unheard of to have a trial of history. And I'll explain a little bit more what I mean by that. But just for example, if you go back to the Eichmann trial, even though Eichmann very much privileged the voice of survivors, the very first witness at the Eichmann trial was not a survivor. The very first witness was a professor at Columbia University named Salo Baron, who basically offered this very lengthy lecture on the history of anti-Semitism. Likewise, if you go and look at the record of Demjanjuk's trial in Jerusalem, the very first witness was a historian named Yitzhak Arad, who was at the time, he was also the director of Yad Vashem. So I think it's almost no exaggeration to say that Holocaust trials, they actually introduced almost kind of a revolution in the use of historians in criminal trials. If you look at the practice in the United States, so I already said a little bit earlier that American prosecutors dealing with the problem of Nazi collaborators, they never were compiling evidence for the purposes of bringing forward criminal cases. They were bringing civil cases, denaturalization, and deportation cases. And they ended up creating, American investigators or jurists, they ended up creating a very special unit within the Department of Justice called the Office of Special Investigation. It's now called Human Rights and Special Prosecution. But this Office of Special Investigation, early on they did a very interesting thing where basically, typically in a prosecutorial office, you'll have prosecutors and you'll have investigators. People do like standard investigations. What the OSI did very early on is they took their regular investigators and they just fired them. They said, we don't need standard investigators when we're dealing with this type of crime. What we need is we need professional historians. And so they got rid of these standard legal investigators and they hired instead professional historians because they understood that the juridical determination of guilt really couldn't be decided without the insight of these historians. Now, this unusual wedding of jurists on the one hand and historians on the other, it has actually aroused some controversy. In 1997, a well-known French historian of the Vichy period, this André Rousseau, this Professor Rousseau, he was asked to testify at the trial of Maurice Papon. And Papon was the former French budget minister who in 1998 was convicted of complicity in crimes against humanity for his actions as a police official during the Nazi occupation of France. And so this Rousseau, this historian, was invited to testify, and he actually declined, he refused to testify. And he did so because he said he worried about what he called a judicialization of the past. He worried, and this is a letter that he wrote, he said he worried that he worried about trials in which, this is a quotation, beyond the judgment of particular individuals, the declared goal is to eliminate an entire era in its politics. Now, I respect Rousseau's principled stand, but I actually find his attempt to erect some kind of divide between law and history as really kind of an untenable divide, particularly when you're dealing with Holocaust or mass atrocity trials. Because I think when it comes to these state-sponsored atrocities, the questions of history are inescapable because these crimes, by definition, these crimes deal with large communities and actions that have been perpetrated over many years and very often over very large geographical areas. Returning, for example, to Demjanjuk's trial in Munich, I think it's fair to say that basic legal questions, they were absolutely unanswerable without the insights of professional historians, or maybe to put it somewhat differently, that the determination of his guilt as a legal matter really turned on answers to aggregate historical questions. I'll try to be a little bit more specific about that and to try to highlight what the problems were, or the particular dilemma that prosecutors in Munich faced. So as I said, he was tried as an accessory to murder. The prosecutors in Munich, I think it's fair to say, had evidence beyond a reasonable doubt that he had served as a guard at Sobibor. So it was very clearly established that this guy had been a death camp guard. The only problem was the prosecution had absolutely no evidence whatsoever about his specific behavior as a death camp guard. No idea whether he was cruel, benevolent, nasty, shot, nothing. All they knew was beyond a reasonable doubt that he had served as a death camp guard. Now that would typically create quite a problem for the prosecution, and the way the prosecution in Munich got around the problem is, I really think, quite brilliant, and it was both simple but quite irresistible. And the theory that the prosecution developed was very specifically tailored to the reality of Sobibor. And Sobibor was one of the SS's pure extermination facilities, along with Belzec and Treblinka. And the prosecution's theory kind of worked almost like a logical syllogism, like a three-step logical proof. And it kind of just went very simply like this, that all Sobibor guards participated in the killing process. Demjanjuk was a Sobibor guard, therefore Demjanjuk participated in the killing process, and therefore accessory to murder. Now, the reasoning was deductive, so the conclusion has to be true if the premises are true. Now, again, this minor premise that Demjanjuk was a Sobibor guard, this, as I said, was very solidly established by documents. There's really kind of, there could be no good faith debate about whether he had been a guard as not, even though, as I mentioned, he continued to insist that he never had been one. The problem, again, so the major premise is the one that commands our attention, that all Sobibor guards participated in the killing process. Now, this in essence is an aggregate historical claim, and it really could only be proved by having a pretty comprehensive historical study of Sobibor and its Triniki trained guards. This just happens to be an image of the Sobibor camp. It's in, if some of you think you're having some kind of like strange neural problem when none of the words are familiar to you, it's in Dutch. And the only reason I chose a Dutch map of Sobibor is because almost all the victims at Sobibor during Demjanjuk's tenure there were Dutch. And so just kind of out of memory of them, I kind of chose a Dutch map of the Sobibor camp. So the first thing that historians established was Sobibor was a death camp. Now, of course, this is well known, but still, a comparison with someplace like Auschwitz is really quite telling. Auschwitz, of course, was a hybrid facility. It was part death camp, but it was also a very large, you can say, slave labor camp as well. About 1.2 million persons were deported to Auschwitz. Of those 1.2 million, about 100,000 survived. So if you think about Auschwitz almost as a disease, I mean, you're talking about a death rate of over 90%. So Auschwitz was an exceptionally lethal place. You compare Auschwitz to the pure death camps, Sobibor, Treblinka, and Belzec, about 1.5 million Jews were sent to those three camps. Of that 1.5 million Jews, 125 survived. So just 125 survivors, and this really underscores the fact that these camps had one purpose and one purpose only, and that was to murder Jews. So for example, in the case of Auschwitz, you couldn't necessarily say with any certainty that, let's say someone had been one of the 6,000 guards at Auschwitz, having been a guard at Auschwitz didn't necessarily mean that you were participating in a genocidal process. But in Sobibor, that would not be the case. The mere fact that you were a guard at Sobibor necessarily meant that you were a participant in the genocidal process. The other important insight from historians was that the guards at Sobibor, they were all generalists. And by that I mean that it's not the case that any particular guard at Sobibor was just responsible for cooking the meals or just responsible for folding laundry. They all were basically mobilized and participated in the killing process when trains arrived. And that again was a very important fact to establish. And one of the things you might notice just looking at this map of Sobibor is, you might have some image of Auschwitz, and I think when we have these images of Auschwitz, we have this image of this massive camp with kind of barracks disappearing towards the horizon. Whatever else you can say about Sobibor is it's tiny. There were 15 to 20 SS men at Sobibor and about 100 to 120 guards such as Demjanjuk, and that is it. And so by establishing that Sobibor was a killing machine and that all the guards were participating in the killing process, the court was able to conclude that Demjanjuk must have participated in the killing process. Now, that did not entirely end the case because there was one critical question that remained. And the last critical question was, had he served voluntarily? Remember, Demjanjuk was not a Nazi. He was Ukrainian, he wasn't a German, he wasn't a Nazi, he was a collaborator. And he'd been taken as a POW. So had he served voluntarily? Now this, of course, again, was a question. Voluntariness is a legal idea. Only the court can ultimately determine whether it was voluntary, his service, or not. A historian can't tell a court whether someone behaved voluntarily any more than, let's say, a ballistics expert could tell a court whether a shooting was premeditated. But here again, the narrative that was shaped by the professional historians who testified at trial, again, it didn't simply influence the court's ultimate verdict, it made it possible. These historians estimated that of the 5,000 collaborators who were trained at Trinity, that up to 1/5, that is fully 1,000 of these 5,000 men, they just deserted their posts. And of the Trinity trained guards who deserted their posts, remember Trinity was the SS facility that I discussed at the outset, of these Trinity trained death camp guards who fled, these historians are also able to say something about the consequences of being caught if they had fled. Now, if they fled with their weapons, that was a serious offense, and they would likely face execution. But if these Trinity guards fled without their weapons, and then were later caught by the SS, they really typically suffered rather slight punishment, and soon enough were rotated back into service as guards. The court concluded from this material that Demjanjuk, therefore, had had a meaningful opportunity to desert, and the failure to do so indicated that he had served voluntarily. Now, some have questioned that conclusion, though I take it to be correct. But that, in fact, is not even really my main point. It's to show this kind of very interesting process by which a question of individual guilt was answered by recourse to these larger patterns of historical action. Now, some may find this trial by historical deduction disturbing. I was in Munich at the time of Demjanjuk's conviction, and at the time I heard various expressions of sympathy for the former guard, who, after all, was 91 years old at the time of his conviction. And some people said there had never been any evidence that he was particularly cruel or vicious. And then I heard other people come along and say, no, don't let that old man routine fool you. He must have been really secretly a monster. But to my mind, both views miss the point. The fact that the Munich court convicted in the absence of evidence of his personal evil or viciousness, that's what accounts for the ruling's importance and even what I would say its greatness. Because again, to convict only in the presence of proof of evil or viciousness is to treat a Holocaust crime as a garden variety criminal case. That is, that kind of conventional crime that I mentioned at the outset, in which crime is just understood as an act of deviance. Demjanjuk's Munich trial, by contrast, it understood that mass killing is not simply the result of personal acts of evil, but it's part of an exterminatory process. And when it comes to state-sponsored atrocities, guilt, the court realized, is not to be measured simply in terms of cruelty or nastiness, that guilt follows function. And that was, in my mind, the simple and the great insight of the Munich court in convicting Demjanjuk. So, thank you very much. That's the formal part of the presentation.
So,
Yeah.
1 second.
Oh.
I'm gonna.
And I now see that the Demjanjuk support team that had arranged the jackhammering during the early part of my lecture has now ceased, so I'm glad that we outlasted.
Okay,
Yeah.
so we have time for some questions. Do you want to sit down? Or, no, you want
No,
to.
I will
You
sit
want?
down.
Okay. Okay. Okay, let's start. Speak to the microphone, please.
I am.
Yes.
It's right in front of me. You had said that they were, I don't know if it's on, I'm speaking into it.
Can you, I don't know, can you hear
I
me?
meant,
No.
I meant hold it closely. 'cause
I can't
know
hold
the
it.
microphone
Yeah.
Oh my
and
God.
I-
I'm practically kissing it.
Yes.
Okay.
Great.
You had talked about documents that came, that were released from the Soviet Union.
Yes. Yeah.
What I'm not clear is, how did those documents show that it was this man who was the
Yeah, who was?
What was it, did they have fingerprints, what was
Yeah.
it that showed it was him?
That would show that, well, so the question, did you ever hear the question?
Not really.
No, so the question was, I had mentioned that when the Soviet Union unraveled, that documents came to the fore that made it clear that Demjanjuk was not this Ivan the Terrible. In fact, this guy, Ivan Marchenko, was Ivan the Terrible. And the question was, what was the nature of that documentation? And the nature of that documentation was, the Soviets actually conducted a lot of trials of former Triniki guards, lots of trials of them. And so they had tried a lot of guards who had done service at Treblinka. And in addition to trying these people, what they also did is they interrogated them because they wanted to get the names of everybody else. And they have these files of all these Treblinka trials. And in these files, you find all these people, these accused being interrogated, saying, well, there was one guy who was a total psychopath, and his name was Ivan Marchenko. And then you go to the next thing, and they say, well, there was one guy who was such a crazy sadist whack job, this Marchenko guy. And then they go to the next one, and it's like, and they actually then ask, like, some of these people were still alive at the time, and they said, like, what about Demjanjuk? It's like, I didn't know any Demjanjuk. Who was the whack job there? Oh, Marchenko was the whack job. He was the one, I didn't even want to hang around Marchenko. He was so terrifying. And so they had a lot of people naming Marchenko. And, I don't want to get too much into, do you want the whole, like, bizarre, the full bizarreness? Okay, so they actually had photographs of him as well. They ended up having a photograph of this Marchenko. They had his marriage certificate. They had a woman who was his consort during the war. They had a lot of information pointing the other direction. One thing, though, in terms of, like, how you could imagine, like, Excedrin headache for prosecutors, is one thing that made everything very bizarre is that if you look at one of the forms that Demjanjuk filled out when he is trying to immigrate to the United States, he enters in his mother, he has to enter in his mother's surname before she married. And he writes down Marchenko. And so then suddenly these prosecutors are like, maybe Marchenko and Demjanjuk are the same guy. How do we know that they're really different? Maybe he was using his mother's surname at the time. He didn't want to use his actual name. But no, we have very, very certain evidence that he was not Demjanjuk at Treblinka, that he was never at Treblinka. The other thing is, I have to say, I don't know if you want to, can we get to that
Yes.
PowerPoint
That's
B?
fine.
You want Doc, as you asked? Yeah. Quickly.
Yeah.
Yes.
Very good. Two presentations.
Yes.
We have photographs.
This is just meant to saturate your retina with images of the cover of the book, so that you walk out and go, my book.
The next one.
No, just a little. That's not right here. Yeah. That was actually Demjanjuk's house. That was his suburban house. But this was something. This is one of the principal pieces of evidence against him. This was his service ID at this Trinity camp. So this is Demjanjuk service ID, and it's pretty clear. That is Demjanjuk, and the service ID itself has him at Sobibor. Never mentions Treblinka at all. And okay, I'll leave it at that, because I could tell you even more how prosecutors got unbelievably confused. But tell you, well, I'll let maybe Goodland ask the question. Someone asked, how else were prosecutors confused?
How many Ukrainian or other prisoners of war, the Germans, became prison guards or that type of thing? Is that known?
Yes.
And also, you said he was captured or suspected in 1975, denaturalized.
Yeah.
And the trial wasn't until 87. What
Right.
took 12 years?
I'll answer the second question first. What took 12 years is called the American legal system.
Yes.
The American legal system works incredibly slowly. And in particular, I think it is safe to say that if you study any of the INS, Immigration and Naturalization Service cases, the process of denaturalizing and deporting an American citizen is exceptionally difficult. It is far easier in terms of the procedural hurdles that you have to clear to convict someone of first-degree murder in the United States than it is to strip that person of their citizenship and deport them. So there were many, many legal hurdles that the American prosecutors had to go through in order to ultimately lead to his deportation. So very, very elaborate and slow process. The first question you asked was about numbers. About 5,000 of the Ukrainians trained as death camp guards. It's about 5,000. They weren't all Ukrainians. Some of them were Estonians, some of them were Lithuanians, but the overwhelming majority were Ukrainians.
How long did the second denaturalization take?
The second denaturalization also, it took a long time. It was something where he had, after the Israeli Supreme Court voided his conviction in 1993, he came back to the United States late summer of 1993, and he was then denaturalized in 2001. And then from 2001 to 2009, again, the process of kind of exhausting legal remedies ran its course until he could be ultimately deported to Germany.
Two quick questions. Number one, what did you think of the fiction film about the case? And
Yeah.
secondly, what happened to the real Ivan Carroll after the
Yeah,
war?
so this Ivan Marchenko, it's a little bit hard to say with absolute certainty that he died at the end of the war, but all evidence points to that he fought with partisans in the Balkans and was killed fighting with the partisans in the Balkans. So all evidence, and because I mentioned the Soviet trial, the Soviets actually made a real effort to find this guy, and all the evidence suggests that he was killed in action fighting with partisans at the end of the war. You also allude to a film. Some of you might have seen this movie with, I think Jessica Lange won an Academy Award for her performance in this. This was a movie called The Music Box. It was by the famous director Costa Garbus, and it was based on the Demjanjuk case. But of course, it was based on the Demjanjuk case at the time when everybody believed that he was Ivan the Terrible. And so, do I think it was a great movie? No. Do I think Jessica Lange made a good performance? Yeah. But it is kind of one of those ironies that, in fact, it was made at a time when we had a very, very different understanding of who this Demjanjuk character was. And of course, our understanding had to really dramatically change once we understood that he wasn't who we originally thought him to be.
Yeah, I have a legal question.
Yes.
Green Hackworth codified international law before the war and did not include crimes against humanity. What about the legal precedent of ex post facto?
Yeah.
How can someone be tried for something which was not a crime at the time he did it?
Right.
And the other question, just since you're from Yale, there was a fellow who was head of Eastern language at Yale who created actions against the Jews.
Yeah.
And the Yale student newspaper